before the summer started. Before you all get off on your much-deserved summer break, we're going to talk about this really important topic, preventing harassment and discrimination in the workplace. Like I said, I've been doing this for quite a while, and I just find that harassment law is one of the most misunderstood areas of law. There are a lot of people who think they know what it is. Oh yeah, that's harassment. And when you actually talk to them about what's going on, actually that's probably not harassment. On the flip side, people are like, well, that's not harassment. Yeah, actually it probably is. And so we're going to spend a little bit of time this morning, take an hour of your morning, to talk about what it is, what it isn't, what to do if you experience or observe harassment at work, what your entitlements are. Josh is going to get into the district policies, so kind of a very, very clear direction about what you can do. But I hope you'll, at the end of this, walk out with kind of just a better understanding of what it is and, again, what to do if you experience it. I'm going to start with a little pop quiz and to get us just thinking about some of the concepts that we'll be talking about over the next hour. So let's start with the first one. If you engage in harassment, you can be sued individually and held personally liable for damages. Is that true? Yes. It is true. In Washington, not under federal law, but Washington goes further in terms of protecting us from harassment in the workplace. And we're seeing this more and more. Plaintiffs suing not only their employer, but their individual coworkers who've engaged in harassment. So all the more reason, right, to understand what it is, since you can be sued for this kind of behavior. Big kind of stick that goes with this law. How about the next one? Teasing an older coworker about memory loss and Alzheimer's disease may constitute age harassment. True?
Yeah.
So, true. As we'll talk about, harassment is a form of discrimination. So we have all of those protected classes, right, under the discrimination laws. Sex harassment is one, sex discrimination, but there's also age discrimination, racial discrimination, disability discrimination, and all of those protected classes can actually support a claim for harassment as well if it's based on protected status. I remember my mom was an elementary school principal, and when she turned, I can't remember now whether it was 50 or 60, her staff decorated her whole office. They draped it all in black crepe paper. They made still in my parents' garage, this walker with a bike horn and a cup for dentures, and just made this whole big joke about it. And now I look back on that going, oh gosh. I will tell you, she loved it. She thought it was hysterical, and she still has that walker. But the bottom line is when we tease people about things that touch on protected class, there is this potential that we could also be talking about harassment. It very much depends on how that is received, right? Which you're not always going to know whether my mom would have burst into laughter or burst into tears in response to that. But she, again, loved it. Next one. If you didn't mean to offend a coworker, you didn't engage in harassment. True?
Oh.
Biggest, fattest, I'm glad to hear the false. Biggest, fattest false on here, and we're going to talk about this notion that intent really doesn't matter. Whether I intend to offend a coworker isn't relevant. What is relevant is the effect of my behavior on people that I work with. I do a lot of investigations as part of my practice, and I see a lot of what I refer to as well-intentioned harassers. They are people that maybe think they're being funny and they're trying to be entertaining. Others that maybe are romantically interested in a coworker, which is all just fine until it's creepy, right? And then we have to start talking about harassment. And so we'll talk about that a little bit more. How about the next one? The law prohibits harassment by coworkers. Harassment by third parties such as a constituent, a member of the public, a parent, a vendor is beyond the scope of harassment laws. True?
False.
False. This one used to be true. Courts kind of said, boy, an employer can really only control the behavior. It's only responsible for the behavior of its employees, right? The case that changed the law or started to push the law further on that point was a waitress who had these guys coming into her restaurant, sitting in her section and touching her inappropriately and propositioning her. And eventually courts came around to the fact that, you know what? That's her workplace. She's going to work. The employer, yeah, they can't fire those customers, but they can refuse service. There are things that an employer can do. So now, under the current state of the law, really your workplace is really wherever you are when you're carrying out your job duties. So when we get to talking about the district's harassment policy and options you have for reporting, those kinds of interactions can also be raised and reported, and the district can take steps to address those. If your coworker always laughs at your dirty jokes, they can't later assert a claim for sexual harassment. True?
False.
False. A lot of misperceptions around that. Oh, well, they must think this is funny. They like it. We're going to talk about the notion that in order to be unlawful, harassment has to be unwelcome. It has to be objectionable to you. But there are a lot of instances where maybe somebody kind of goes along with behavior. Why might somebody not complain about offensive behavior?
Retaliation.
Fear of retaliation is probably the biggest one, or this desire not to rock the boat or get sideways with your work team, so you kind of go along with behavior. The fact that somebody did go along with behavior certainly doesn't preclude them from saying at some point, you know what, this isn't okay, I'm not comfortable with this. So if you're in that boat of maybe being subjected to behavior and you haven't really spoken out, that doesn't mean you can't at any point. These kinds of behaviors have a way of festering or progressing. People kind of banter, and then somebody takes it a little further, and suddenly we've got some really objectionable behavior happening. And so we'll talk about that a little bit more too. How about the last one here? If your supervisor calls you stupid in front of others and constantly belittles you in other ways, that's unlawful harassment. True? So this one is kind of a depends. I would actually say that that particular statement, just as written, is false. That's what I call more like bullying behavior. As we're going to talk about, harassment again is a form of discrimination. So it touches on race, gender, disability, age. If you just have a jerk for a supervisor, that hopefully violates district policies, but it becomes actually illegal where it touches on protected class. Every couple years, the legislature in Washington introduces anti-bullying legislation. It's never passed. It's not technically illegal right now. But this kind of EEO jerk, the equal opportunity jerk, who's just a jerk, regardless of protected status, may not be engaging in unlawful behavior. But as we'll talk about as we go forward, if you have a concern or complaint about abusive, demeaning, derogatory behavior, that is still something that you can and should bring up to human resources, follow the policy that you have. You don't have to worry about whether it constitutes harassment in the legal sense. That's part of what your employer needs to assess and navigate. So you have the ability to come forward regardless of whether it qualifies for harassment under the law. I have a couple of slides here just on primers about discrimination law, just to help us understand kind of what the law is in this area. There's kind of this alphabet soup of federal laws. Title VII is the big federal law that prohibits discrimination on the basis of race, gender, national origin, religious beliefs. We've got some other state statutes. ADA, Americans with Disabilities Act, prohibits discrimination on the basis of disability. The ADEA, Age Discrimination in Employment Act. Note that to be in the protected class for age purposes, you have to be age 40 plus. Technically, you can tease and banter the youngins of the room. Sounds younger and younger to me every year. I'm like, 40? That's like nothing. You're a baby. But nevertheless, that's what the law says is in the protected status. Note that our state law in Washington also prohibits discrimination on the basis of sexual orientation. That includes gender expression, gender identity, the way you identify in a gender context. Domestic violence victims are also a protected status under Washington law, as is marital status. And then of course we have district policies which basically reflect all of these prohibitions and prohibit discrimination within the district. A couple more just vocabulary terms and concepts in the discrimination arena. There are three different kinds of discrimination. Disparate treatment is just treating two people differently with respect to hiring, firing, promotion, compensation, based on protected status. Pretty straightforward, most probably common kind of discrimination claim we see. Disparate impact is a more subtle kind of discrimination. It's where the policy or practice looks facially neutral, but it has a disproportionate adverse impact on certain groups. So a kind of silly example that I'll give is if I'm hiring a receptionist for our office and I say, you have to be 6'2" or taller. Okay, that doesn't really discriminate, right, on any protected status, but who's that going to impact? You know, we don't know that many women, right, who are 6'2" or taller, and is that legitimately related to your ability to do the job? No. Another example that's very recent, Washington now has, it's called Ban the Box. It's a relatively new law that says unemployment applications, with some exceptions, which probably in school settings would be an exception, but you basically don't, as an employer, can't ask somebody if they have been convicted of a felony on the job application to screen them out of employment right from the get-go, because that question has a disproportionate impact on certain minority groups. And so, yes, it might still be relevant. We consider it later in the job process, the hiring process, but not at the outset. So there might be, again, subtle practices that don't seem to have a connection to protected status, but have a disparate impact. Then we get to what we're going to be spending our time on this morning, which is harassment. Again, it's a category of discrimination. And there are a couple different kinds. Quid pro quo, what does that mean? This for that. That's the stuff that you're seeing out of Hollywood and elsewhere, where some big producer says, hey, if you want to be in my movie, come to my hotel this weekend, or you're never going to work again in this industry if you don't sleep with me. Something, it's almost always in a sexual context, power imbalance, where somebody's being either rewarded or threatened based on sexual behavior. Blatant, pretty clear, easy to recognize. In contrast, we have hostile work environment harassment, which is the other kind of harassment, much more common, and yet it's much more subtle and hard to know when it's happening. And this is when I say, people have a lot of misperceptions. This is the category where people sometimes think they know what it is and don't. I kind of joke around how people use the words harassment and hostile work environment to refer to kind of anything negative in their workplace, right? Anything that makes them uncomfortable. And yeah, in a dictionary sense, that's probably true. But they do, as we'll talk about, have legal underpinnings for them to become unlawful. Okay. I am stuck here. Oh, I just wanted you to get up. Okay, so I don't want to get too deep in the legal weeds, but I do think because this concept of hostile work environment is a little bit nebulous, it helps to kind of understand how a court is going to look at these kinds of allegations. What are the actual requirements that make this behavior illegal? And so this slide just indicates the 4 general requirements. 1, it's unwelcome, which sounds pretty straightforward, but I will tell you that's where a lot of the litigation is around, whether behavior was unwelcome or not. Second, again, it has to have that connection to protected status. So not just unpleasant behavior, but something that is tied to someone's protected status. The third element, at what point is it bad enough, basically? At what point is it sufficiently severe or pervasive? So it could be severe, one severe incident, or pervasive, a lot of less serious but ongoing behaviors that at some point cross the line and make the behavior illegal. And then lastly, the offender knew or reasonably should have known of this behavior and failed to take corrective action. We're going to break these down even further, but this last one is important. It's kind of why we're here. The law recognizes that employees are going to go interact with each other and have conversations with each other that the employer's not really aware of. And the employer isn't responsible for that interaction unless and until it knows of inappropriate behavior and doesn't do something about it. So important that you all understand, what behavior is problematic, that you can and should bring it to your employer's attention, because that's what triggers the employer's ability to take corrective action. All right? By the way, we're going to have questions at the end, but if I say something that is confusing or you're wondering how it might apply, throw up your hand and let me know. Just flag me down. So going back to that first element, which I signaled as one of the most litigated, I always talk about my dad when I talk about this element because he is one of those guys who's got the massive joke email distribution list, like 75 people on this list, and I get these jokes, and they range from dumb to political. I just never know what I'm going to get, and it's to the point where I have to close my office door before I open an email from my dad because I don't know what's going to pop up on my screen. But the problem was I would see, the distribution list, and I'd see, his company email, like all of these people that he works with. Like, Dad, you work with her and him and her, and you can't send jokes like this to people at work. You know that, right? And he's like, they love it. No one's told me they don't like it. You should see what so-and-so sent me. I'll forward it. Like, you're not getting this, Dad. This is inappropriate at work, even if it's welcome, because you know what? Half those people are in your work group and you supervise them, right? Are they gonna feel comfortable saying, Bob, this is offensive? I used to have nightmares that someone was printing out all of Bob's emails and like stacks of baker's boxes. And that someday my own dad, despite what I do for a living, is going to be accused of harassment. He just couldn't get it around his head that, unless and until somebody tells me, they must be okay with my behavior. And that's just not necessarily, right, the way that the world works. Certainly if somebody does complain about behavior, that's an indication that it's unwelcome. But, we're not all like this gal holding the sign, I am offended. I mean, we might kind of non-verbally indicate our objection by walking away or rolling our eyes or crossing our arms, shaking our head. Those are our signs. But there might be situations where either someone fears complaining because they're concerned about retaliation. Sometimes courts will even say, you know what? The behavior was so terrible that I'm not even going to require somebody to complain. This employer should have known this behavior was offensive and should have done something about it. So we can't, the bottom line is we can't simply assume that, hey, unless somebody tells me otherwise, they must like my sense of humor, or they must think this is funny, or it must be welcome to them. Another consideration here is, did the employee participate in the conduct? As I mentioned, this is a category of human interaction where people tend to get more and more comfortable with each other. Maybe there's some joking and banter, and then somebody takes a little further, and then somebody takes a little further, there's a prank, and suddenly it's snowballed into something that at some point crossed a line. And I told in the last session a case that came through our office involving this police officer, a female police officer. It was described to me that she was very much kind of one of the guys, went along, a lot of banter. They probably, told some kind of off-color jokes to each other. She had no problem with it. So apparently one of the officers, the male officers, thought she was such a good sport that wouldn't it be funny if we handcuffed her to a rolling chair and pushed her into the guy's locker room while some guys were showering, because she's such a good sport, And the fact that she laughed at our jokes earlier, does that mean that she could not sue for sexual harassment later? No. I mean, the fact that maybe she went along with some of the banter earlier did not prevent her from saying, wow, this went too far. And obviously we're talking about this because it actually became a litigation case. But it illustrates kind of the way that these behaviors can snowball or progress and become problematic. So the fact that, if you're sitting here today and you've been maybe subjected to behavior that is offensive to you, and you haven't said anything because you didn't want to rock the boat, because whatever your concern was, that does not preclude you from saying, hey, you know what, guys, this has gone too far. I'm just going to let you know I'm not okay with this. You need to knock that off. You have that right at any point. Bottom line, silence does not mean the behavior is welcome. So I have a bunch of case studies kind of sprinkled throughout the materials here, and this is the first one. This one's about Tom. So Tom's this really popular guy. He's seen as warm and caring, so people go to him with their problems. He's known to kind of put his arm around somebody or give them a hug if they're feeling down or stressed. Should there be any concern about harassment here? Yes? No? Maybe so? I mean, I would say with this fact pattern, not necessarily, but I did want to emphasize that touching crops up in a lot of harassment cases. People have very different comfort levels and comfort zones around touching, right? Some people, like, I grew up in a very touchy-feely family. Other people, you can tell they have a space bubble and, don't like to be touched. And we need to respect each other's differences. There are a lot of kind of misperceptions around touching, and courts have to analyze, is it sexual touching? There was a case out of California last year involving a sheriff, and the facts indicated that he was a prolific hugger, and he only hugged women. And whenever he came around, and there was a woman, the women would be like, "Get a desk in front of me." He just would hug everybody, not the men. He would shake the men's hands. But the court went into this big analysis about, it's only hugging women, it's a chest to breast hug. I mean, they're analyzing it and where exactly his hands were. So it's not necessarily a bad thing to have this warm and caring, touching person, but it needs to be welcome. If you're not a hugger, not a toucher, just say, hey, high five, I'm good with a high five, or a fist bump, dude, or gal, whatever it is. I think what crops up in a lot of harassment cases is the massager, the person who goes around, massages. I'm here in the crowd. Probably not a cool thing unless somebody's actually paid you a fee for the service or something, or you're married to them or something. So just be mindful, be thoughtful about touching, again, because some people are just very uncomfortable with it, and may, even if it's not intended, may misconstrue that kind of contact. That third element, at what point is it bad enough? And I have this kind of like color continuum. It's severe, again, or pervasive. The more threatening or intimidating behavior, the less often it has to occur before the law says, this is unlawful. Other kinds of behaviors, kind of the joking, the teasing, the banter, the court's going to look at how often is this happening, how long has it been happening. My point to you is, if behavior is happening that's inappropriate, raise it. Let's nip it in the bud at the lowest possible level before we have to talk about at what point did it cross the line and become illegal under the law. We can, address and counsel people and put them on notice that, hey, that's not okay. Okay, great, we've done it, we've taken care of it, it's not continuing, and we don't have to analyze at what point it got over the line. I don't want anybody to walk out of here with like, I get 3 free dirty jokes a year. As long as I'm under that threshold, I'm okay. Because even the first one, you tell an inappropriate joke, hey, that's not okay. Again, okay, great, we're all good. Next case study. This one's about Joseph. He's been on light duty for a number of months due to a back condition. So he's missing a lot of work when his back flares up. And then even when he is at work, he's kind of on light duty, so other people are having to do a lot of the more onerous tasks for him. And other people are getting frustrated, right? They're having to work more overtime or work longer hours, or just having to spend more of their time doing the kind of less desirable tasks. And they're starting to get mad, and they're referring to him as a slacker and a faker. Somebody put a note on his car telling him to get back to work or quit. He says that they're giving him dirty looks. So the question for you, is this harassment?
Yes.
What do you think, yes? Yeah, this fact pattern is based on a lawsuit against Fred Meyer for an employee who was on light duty due to a workplace injury, and it was frustrating to, in that case it was her, to her coworkers. But the coworkers engaged in what I call self-help. They started picking on her and expressing their frustration towards her. And the court said, we don't think this employer did enough to protect her from that behavior. That's not to say, I should back up. When an individual has a disability under the law, employers have an obligation to provide reasonable accommodation, which may include things like granting leave, providing temporary light duty, those kinds of things. And it may have an impact on other employees. But that's just something that we need to absorb. Certainly if it has an unreasonable impact, that's something that could be communicated to supervision, management, that this is unacceptable for me to be picking up all these overtime hours. That may go to whether the accommodation is reasonable, but the bottom line is not engaging in this kind of direct picking on of the coworker, because in this case, the court recognized that this was a form of disability harassment. The employee in that case had a legitimate documented health condition and should not have been mistreated because of that. Again, I don't want to beat a dead horse, but I need to really emphasize this point, this notion that intent, the fact that you didn't intend to offend a coworker is not, at the end of the day, relevant to a harassment claim. And that can be especially tricky because my behavior, what matters is the effect of my behavior on someone else. And I may not even realize that my behavior is offensive because I'm not in that culture, I'm not in that age generation, I'm not in that racial group or that sexual orientation group. So we need to be sensitive to the fact that other people's perceptions may differ depending on that protected status, and try to be respectful. And sometimes that also means educating our coworkers. If they say something that, wow, in my culture that's really offensive expression, letting somebody know that so that they can be sensitive. And if they continue and persist in using offensive terms or language, then that's something that, yeah, could certainly be implicating a harassment kind of claim. Okay, another case study. This one is about Russell. He recently started work for the district, and Serena has a crush on him. She's invited him to lunch, she's making him some cookies, and she recently invited him to a Seahawks game. Russell's not interested in Serena, although he'd really like to go to the Seahawks game. He doesn't want to get her. And so he's becoming now uncomfortable with her attention. So question for you, is Serena harassing Russell?
Nope.
What do you think?
Nope. Guess it's unwelcome.
I don't think, at this point I would say no, but you can see that this could become a situation where Russell is being harassed at work. I think the turning point to me would be, has he indicated, I'm not interested, this is unwelcome to me. This is a classic example of that intent doesn't matter. The last thing in the world Serena's trying to do is harass him, right? She's trying to initiate a romantic relationship with him. But there's a point at which her attention becomes, back to my earlier expression, creepy, and makes him uncomfortable about even coming to work. So this is a situation that could become something an employer needs to deal with. If this is, something that you've experienced, I think the most important thing would be to say initially, thanks, but no thanks, basically. And then if the behavior persists, at that point, yeah, it is absolutely something that could be raised via a harassment complaint. I mentioned this earlier, the statistics are amazing on how many of us meet our significant others or people that we date at work. We spend a lot of time here, right? This is where people meet. So there's nothing inappropriate about initiating or making overtures about, whether somebody is romantically interested in you. But we need to also respect the fact that no thank you means no thank you. All right, so I do, as I mentioned, I do a lot of investigations, and it's rare that there would just be one kind of behavior that I see in a harassment case. Oftentimes there are kind of different, then this happened and then this happened. So I have this kind of laundry list of things that crop up in harassment cases, and I just wanted to give you some examples of what kinds of things may generate a complaint or concern. One is comments on personal appearance, and that is not like, oh, did you get your hair cut? It looks great, thank you. Great, we're all moving on now. I'm talking about the kind of daily, not just that's a cute new sweater, but oh, that sweater fits you just right, quite that creepy, right? Or calling somebody always, hey beautiful, or hey handsome, or commenting on their body parts, or things like that, where you start to feel uncomfortable with the the personal attention on your appearance. That's something that might crop up. Nicknames is another item. Nicknames can have racial connotations, they can have sexist connotations, kind of the honey, sweetie, dear, demeaning, I'm not your honey, I'm not your sweetie, that kind of thing. We had a case in our office that came through involving an African-American man claimed racial harassment, and part of the concern was that the supervisor referred to him as boy. Offensive, inappropriate, right? So just thinking about nicknames, do they have disability, hey, gimpy? I mean, hopefully we're not using terms that implicate somebody's protected status, whether it's disability, race, gender, etc. Stereotypes, mocking, imitating people based on some kind of protected class can be demeaning and derogatory. I have an example that could have illustrated this, an investigation that I did out of a police department, and it involved a group of detectives who were working with this confidential informant. And as it was described to me, the informant was flamboyantly gay, very dramatic and effusive, and I think it sounded like he took great pleasure in making these detectives uncomfortable. He would fix their tie, comb their hair for them, and say, come over to my place and flirt with them, and they kind of just took it. But then the problem was, they then went back to the police department. And then they would interact with each other and imitate him. So they would talk to each other with a lisp, and they would, flirt and fix each other's ties. And you know, they were directing this behavior towards each other, but I was there as an investigator because there was a concern from another employee who worked in that police department who was gay, and thought, wow, this is really demeaning. They're just mocking. I mean, they're making fun of people based on these gay stereotypes, right? So it wasn't intentional behavior, but you can see how kind of those stereotypes, when they're presented, especially in a mocking way, can be upsetting to people. We talked about touching and how that's quite fraught with potential misperceptions, even if not intentional. Dating and initiating personal relationships shouldn't be a problem, again, unless one or the other is not interested. And sometimes we see harassment claims coming out of relationships where the people have broken up. One person is still pursuing the relationship and the other person doesn't want anything to do with it. So that, unfortunately, sometimes becomes a personnel issue. Work-related off-duty conduct can spill back into the workplace. So your harassment policy doesn't cover all of your personal lives and what you do over the summer or on the weekends, but to the extent there's some off-duty incident that then has workplace impacts, that could be something that implicates the district's harassment policy. So a common example is the relationship, the breakup, and now people are working together and there's this great friction around that relationship. That could become problematic. We're well past the days, the cartoons, posters, pictures, the t-shirts, no Playboy centerfold up in anybody's office or cubicle. That stuff just doesn't belong in the workplace if it's racist, sexist, you know, discriminatory, otherwise based on protected status. Jokes implicating protected status, sarcasm or innuendo. I go back to, I kind of talk about my family a lot. My kids are both college age right now, and they love the show The Office. 100 times, I cannot get through a conversation without one of them saying, "That's what she said." I'm like, oh my gosh, you know, can you get your mind out of the gutter? But that, and I try to tell them, you know, you're going to be employed shortly. And you can't say stuff like that. You can't constantly make everything a sexual innuendo, right? And there are people who can't get through a day without, you know, some kind of sexual reference. And the fact that stuff is on TV or in movies, or, you know, the fact that, hey, that's on network TV, doesn't matter either. They're just things that don't translate to the workplace anymore. I joke again about my family. I come from an incredibly inappropriate family, as you can probably tell by now. Very ironic that I do this. Maybe there's some subliminal reason why I do this. It's hard to offend me because of my upbringing. It's not a challenge. Offline, but yeah. Here, no, but I also recognize, given what I do, that there are too many risks associated with kind of this blending, this off-duty behavior, even if that's very comfortable for you, bringing that into the workplace, because not everybody shares that perspective. So just be mindful of that. Obviously, there's some more extreme examples, slurs and racial epithets, those kinds of things. Staring, leering, kind of checking somebody out constantly, that can make people very uncomfortable. And again, that might not be the only thing, but it might be a combination with, you know, the honey sweetie and the staring and leering and hey handsome, and, you know, making somebody feel uncomfortable in that way. Similarly, invading personal space, you know, leaning over somebody unnecessarily, following them into the file room, and, you know, just invading personal space, making people uncomfortable. I've had sexually graphic comments. There are some people that love to talk about their sex lives. And they come back to work and they're talking about this and that. I've done investigations where I have to Google things like, what does that even mean? But people feel, for some reason, very free to talk about, they're sitting in the lunchroom or whatever, talking about things. But, you know, even if you're not talking to somebody, like you're talking to somebody who's sharing their own experiences, there are probably other people in the lunchroom that may be quite offended. So, you know, avoiding those kinds of topics. Email and internet, the mother lode in this area. You all know, in a public sector environment, that documents and records that you generate can become public records, can become available to anybody. They're also incredibly powerful evidence in harassment lawsuits, and they get subpoenaed in that context. And that stuff, I said to my dad, I just had these nightmares of them, because it never goes away. And people will never stand in front of a lunch, in a lunchroom and tell a particular joke, but it's really easy to hit forward. It's really easy to, just, share. And yet it's almost worse, because that stuff, like I said, it never goes away, and it's taken out of context of your friendship, out of context with the relationship, and it looks and feels very different. So avoid any kind of inappropriate email, internet use, same with texting. And then I added this last bullet item called microaggressions. Has anybody heard that term before? Yeah, it's kind of a concept that's getting a lot of attention, and I added a slide here. And basically what it is, this is one definition, there are a number of variations, but as you can see, everyday slights or indignities, whether intentional or unintentional, that communicate a hostile or derogatory message to someone based on their marginalized group status or protected status. There is a powerful, as I was kind of looking into this, there's this BuzzFeed, if you Google, like I spend a lot of time Googling, right? Google microaggressions and you can get examples, but there's this one BuzzFeed where you can click through and it just has pictures of people like you and me holding signs of statements that others have made to them. That basically, as you can see, depending on the context of who's holding the sign, you can see why they can feel insulting or demeaning. So the first one was like a picture of this person of uncertain ethnic origin, someone of color, but someone saying, "So what are you?" I'm emphasizing your differentness. An Asian American person, being asked, "So what do your people eat at Thanksgiving?" Like, I'm American too. We have, the same things that other people have. Or these other kind of just slights and assumptions that people make. The last one there is close to home, well into the protected age group, and to have some junior person saying, "Do you even know what Snapchat is?" Yes, of course I do. You're insulting me like I'm not, living in this century. So think about those kinds of things. Sometimes they're unintentional. Sometimes they come from a place of curiosity. Oh, I love your accent. But they can, especially depending on how they're presented and sometimes how they're received, can just serve to make people feel different, to call out that, you're different than I am. So again, this may not amount to harassment in the legal sense, but we can be more sensitive to how these kinds of comments may make a coworker feel. This is just kind of this, to underscore this notion that you all have interactions and relationships and friendships and professional relationships with people, and you may have conversations with people that you feel very comfortable with, but I am here to tell you that the interactions that you have, the statements made, get pulled very much out of context, and they sound very different in a deposition, in a trial, where a comment that felt very comfortable to you with a coworker looks very different in black and white. Kind of an example out of a case that came through our office. It involved an age discrimination complaint, and the woman who was the plaintiff in the case was in her 50s, and she alleged that she was laid off because of her age. And in support of that, she said, "My supervisor regularly referred to me as an old bag. She accused me of having Alzheimer's disease." And we're looking at this going, "Oh my gosh, did this manager really do it?" And then you talk to the manager and she's like, "We were friends, and I'm like, we're both in our 50s, and she's 1 day older than me. So we had this running joke, haha, you're so old, you're 1 day older than me." And the case progressed, and ultimately, that context came out, but it made for some pretty uncomfortable moments. So I just use that to illustrate that, the interactions that you have, again, can be taken out of context and made to look very different. So I think a lot of public employees have this notion that, be comfortable that anything you say or send via email, you're comfortable on the front page of the newspaper, right? Kind of the same token, because this stuff can get taken out of context. The employees, this case study, the employees in the facilities maintenance group engage in joking and banter that some would call politically incorrect. So they're joking about Joe's age, Miguel's ethnicity, Amira's religion and her gender, and Pat's sexual orientation. Everyone laughs, everyone participates. Question, is their behavior unlawful? I think there's a technical answer here and a practical answer. I mean, if we could put all of these folks in, under truth serum or a lie detector test and confirm that absolutely it was all welcome to them, I would probably say, okay, it's not unlawful. But lots of huge risk factors for me here. What if other people occasionally interact with this group and find their behavior offensive? It's their workplace too, and the fact that their behavior is not directed at others coming into their workplace can create exposure. What if one or more of them really in their heart of hearts doesn't want to get sideways with their crew, but really it is building and it makes them uncomfortable and it's upsetting and they take it home with them every day. So there's that concern, that just making assumptions. So again, better practice to not engage in kind of behavior and banter that touches on protected status. I am not, I promise you, trying to suck all the fun and joy out of your workplace. I know, especially when it comes to age, we joke and banter quite a lot. I gave the example of my mom, Ginger, with the principal and her office being draped in black crepe paper and how she loved that and thought that was just hysterical. But the reality is it may not be so welcome and funny to everybody. To the extent you can find other things to tease and banter with people about, that's going to be better. Being a Cougar fan, or I don't know, we're Cougars here in this mascot here, Wazoo fan. My husband works for you, so I have to. So you could tease people for being a Browns fan. You could tease, we used to tease this guy in my office because he had like the nicest RV you've ever seen. It's like nicer than my house. And so we teased him a lot about, RV. But so to the extent you can find things to banter and tease people around that don't implicate protected class, that's going to be safer. There are a couple of limitations on what is harassment. The fact that a person declares that is offensive does not make it so. The standard is, would a reasonable person be offended? We all know people, right, who look for ways to be offended. Every day they will find something to be offended by. They don't set the bar for the rest of us. The question is, would a reasonable person find that offensive? And I give this very kind of silly example from a training that I did one time where a gal raised her hand and she talked about how she works with this guy who bicycles to work, and she said, he comes into the office every day in his very tight black and very revealing bike shorts, and he walks right by my desk to go to the locker room. And then at the end of the day, same thing. He goes and changes into these black bicycle shorts, and he just walks right by my desk. I just find this so offensive. Is that something that I could raise as a harassment complaint? I mean, she could raise it, and I think the employer, I told her, I think your employer is probably going to say, a reasonable person would not find that offensive. We're all going to drive home or bike home today and see people going to the gym or, riding their bikes home or whatever. A reasonable person probably would not construe that as offensive. And I told her if she stops and does a little bump and grind in front of your desk, we've got a whole different show going on. But if he's simply going, to change into his work attire and back, that's not, reasonable person would not construe that as harassment. Insensitivity, people being rude, that is not necessarily harassment. Again, you can raise it as a harassment complaint, and that's part of what I do sometimes as an investigator is figure out, does this implicate protected status, or do we just have a jerk? Somebody who's rude and insensitive. Because we use those words, hostile work environment, to refer to anything, that is unpleasant at work. Hopefully, the fact that as a complaint gets raised, if it doesn't implicate protected status, then it may violate a personnel policy. It's not to say it won't be addressed. It just takes on an unlawful character when it also implicates protected status. Same with work-related criticism. A lot of harassment cases come out of, a negative performance review or discipline. This is a hostile work environment. If it's a legitimate attempt to address performance, that's not necessarily harassment, unless, again, it is directed at someone because of their protected class. So just some limitations there on harassment. Another case study, we've got a number of coworkers who were in the lunchroom talking politics, and the conversation turned to gay marriage. So the individuals who were in this conversation voiced their strong opposition to gay marriage, and also made disparaging comments about homosexuality. Sam is gay was also in the lunchroom and was deeply offended by those comments. First question, could this be construed as harassment? Yeah, I mean, there may be a question about whether this one incident rises to the level of being unlawful, but is absolutely something that Sam could express concern about and that could implicate the harassment policy. I include this one because there is sometimes this kind of intersection between, we all have free speech rights as Americans, we can express our views on the issues of the day, but then we also have this right to be free from discrimination at work. And I think that where this conversation crossed the line is not just expressing a political view, but now making disparaging comments about homosexuality. If you are homosexual, are you going to feel comfortable in that lunchroom given that conversation? No, and that should not be the case. So not to say that, you know, the employer here would be regulating the personal political views of individuals, but there's a time and a place for that conversation. And in a public lunch area where other employees are at work, probably not the right place to have that. Second question, does it matter whether the coworkers knew Sam was gay? Nope, going back to that intent thing, doesn't matter. And you know, we see this a lot in harassment investigations. I didn't even know that person was gay. I didn't know what his religious beliefs were. I didn't know she had a disability. I didn't know whatever. That doesn't matter. What matters is the effect of the behavior. So there are, which underscores a further point there, there are going to be times, yeah, when we don't know what protected class somebody is in. We don't know that somebody has a disability. So we need to avoid the behaviors that are disparaging and demeaning without regard to whether they're even directed at a particular individual. Okay, how about this one? District operates a swimming pool that's open to the public over the summer. Chad is employed as a lifeguard. The district has received complaints that Chad is engaging inappropriately with some women who come into the swimming pool. So he's commenting on their bodies, he's ogling them, and he's offering them mouth-to-mouth resuscitation. These complainants, so these are not district employees, these are people coming onto district property. Can those complainants sue for sexual harassment? Yeah, so this is actually a new development in Washington. Our Washington Supreme Court just last year recognized this kind of claim. And it was actually a private sector case against group health. This poor guy was going in for his medical appointments, and this female employee was commenting on his body parts, talking about her sex life, propositioning him, where he was uncomfortable. And so he ultimately sued for sexual harassment, and the court said, wow, we have to think about this. This is not an employment context. These are not employees engaging with each other. This isn't even an employee engaging with somebody coming into their workplace. But the court said, our law is broad enough to cover these kinds of interactions as well. So we not only have to worry about, again, interactions with each other, but interactions with other people. So we see this sometimes with, you know, employees who consider their job to be their personal dating grounds. You know, they're always looking for who they're going to meet and carrying out their duties and propositioning people. Not okay in Washington. And the court said personal liability can result from that, employer liability and personal reliability. And I think what was especially like kind of a heads up moment for a lot of us is that the court said in this context, you don't even have to demonstrate severe or pervasive behavior, because you know what, that guy goes to group health one time and that happens, he may not come back, he doesn't feel welcome. So in employment context, the courts are going to look for pervasiveness, but not in this context. So very important, again, because of the personal liability, that we avoid any kinds of behaviors that may be offensive under those harassment laws. Okay, how about this one? We've got Don, who's a manager, and Jasmine provides admin support for his group. Jasmine complains to HR that some of Don's behaviors make her uncomfortable. So she's saying that Dawn invades her personal space and stares down her top, looks at her chest. HR investigates, and while Dawn is not found to have violated the harassment policy, he is counseled to avoid the complained of behaviors. So after that happens, Dawn is very cool to Jasmine, speaking to her only if necessary and excluding her from work-related emails and meetings. Question, is Dawn's behavior unlawful? Yeah? What is this? This is retaliation, which is just as illegal as harassment. And I include this example. This is based on an investigation that I did. And anybody ever watch Seinfeld? Old Seinfeld? Few fans? We're all too young. Do you remember the close talker, Judge Reinhold? Okay, so Don was the close talker. And he, as I investigated this, the gal was very genuine in her concerns about his behavior. But as I talked to other people in the workplace, the guy is like 6'5", and the gal is like 5 feet, if anything. And he was a close talker, and so even the men in this worker were like, oh yeah, he's just a close talker, he gets right in your space, it's really uncomfortable. So I concluded that this wasn't sexual harassment, he just had poor space respect. But it was especially uncomfortable given the height disparity, so she always felt like he was looking down her top. She said, I only wear turtlenecks, even in August. You know, poor thing, and always had furniture between her and him. I include this example to kind of emphasize that Jasmine didn't have to be right, that the complaint that she made amounted to harassment in the legal sense. She had the right to express that concern and have it looked into. I concluded as an outside investigator, it wasn't harassment, but he needed to be told that this was unacceptable behavior. And if he retaliated against her because she raised that complaint in good faith, that's illegal. That is what's called protected activity. To raise a concern in good faith, even if it's not under the law, you know, unlawful behavior that you're complaining about. So you have the right to come forward, raise concerns, whether on your own behalf or on behalf of a colleague, without fear that you will be subjected to retaliation as a result of that. There's this kind of new movement in the harassment arena around bystanders and the empowerment of us as bystanders to kind of take control of our workplace. So it's not just some, you know, a lone victim being subjected to inappropriate behavior, but we can all be advocates for each other. And if we see behavior at work, whether we're experiencing it or it's directed at somebody else, we can intervene. We can say, not here, not in this workplace. And so there are different things you can do. If you observe some interaction that's inappropriate, respectfully intervene. Hey, can I talk to Sam? Can I talk to you in the hall? Like, extract the person from that circumstance. Or maybe say, hey, I know you don't probably realize this, but that comment was really off color and inappropriate. You know, those kinds of putting people on notice. Discussing with the person, the harasser, the person engaging in the behavior later. Hey, you may not have realized it, or hey, that's not cool. Or talking to the individual who was experiencing that behavior to offer him or her support. Let's go to human resources, I'll go with you, whatever. Or just reporting it yourself. So really, again, being eyes and ears open. You already do that, many of you, in watching for things affecting the kids that you interact with, but we can do that with fellow colleagues at work as well. And again, objecting to harassing behavior, even if it's on behalf of somebody else, is also protected. A few more slides here before I turn things over to Josh. He's going to get into the district policies, but I wanted to make a couple points about submitting a complaint. Again, don't avoid raising a concern because you're not sure if it met that test. That's part of what we do, and the outcome may be different depending on what the facts are, but that's not a concern that you need to worry about. Please, I'll just make a plea for those who investigate these. Provide as much detail as you can, kind of what exactly was said, who was there, do you have the email, do you have the text? It's okay if there was no witness, that's okay, but the more specificity there is around a complaint, because sometimes we start with very nebulous things, that this is a hostile work environment, we're trying to break it down about like what exactly happened. So that can be very helpful. And then of course cooperating with an investigation. A couple other points on an investigation. That's a broad term. An investigation might be as simple as, you know, a follow-up conversation. It could be as, you know, formal as bringing in somebody from the outside. But a couple considerations. Please don't necessarily say, hey, I want to raise this complaint or this concern, but I don't want you to do anything about it. That puts employers in a bad spot because employers may have have a legal obligation to do something about it. Maybe this impacted more than you. Maybe it's more serious than you even appreciate. So, if you come forward with a complaint, respect that sometimes there will be a legal obligation to respond. Again, the investigation depends on kind of the nature of the complaint and the complexity of it. One final point on investigation is sometimes we get complaints, this has to be kept completely confidential, which we can get a lot of the way there. This isn't a situation where we're going to call a big staff meeting and say, Kristen has a complaint, we're going to review Kristen's complaint, and put my business out. But on the flip side, complete confidentiality may not be possible, right? If I'm going to do an investigation, I'm going to need to get the other person's side of the story about what happened. So there may need to be some disclosure, but it's going to be consistent with the need to investigate. So just being aware of that. Last point here is just some kind of big picture thoughts about just diversity and being more aware and sensitive to the perspectives of others. One is self-monitoring our behavior. Again, the behavior that we engage in, with our family and friends away from work just doesn't always translate to the workplace. It's a different environment where there are legal considerations that we all need to respect. Again, recognizing that people may see things differently depending on whether it's their generation, their religion, their cultural background, their ethnicity, etc. And so just being kind of receptive to viewpoints from other people if they say, hey, that's not okay. And then being willing to share yours and educate coworkers about, how something they've said or did makes you feel given your age, whatever. Talked about the social events being imported back into the workplace, or just workplace social events, a company barbecue or some kind of social events. Common theme in harassment cases is alcohol. Kind of affects people's judgment, but it doesn't change the legal standards. So it creates some problems there. And then the last point I'll make before turning things back over to Josh is this notion that nobody deserves or invites harassment. Sometimes a common thing you'll hear in investigations is, well, you should see what she wears, or she obviously wants the attention because look, her behavior. That's never going to be an excuse for inappropriate workplace behavior. No one deserves harassment. Okay, so if you do have questions, we're going to invite questions after Josh comes up, but I will turn things over to him now. Talk about it.
So I really just want to take a minute or two to show you where some of this information is available. Instead of going through and reading it to you word for word, I want to show you where it is and go over a couple of highlights. So here on our district website, you'll see all of our policies and procedures are housed here, available 24/7. The district information, down here by school board, and this is where our policies and procedures are. So the cheat sheet for this is our policies are organized by number, having to do with various things, and the procedures have a P next to them. That's basically our interpretation of how we're going to follow the policy set forth by the school board. So here are a couple examples that specifically address what we're talking about today. As I said, this information is there. If you ever have questions about it, we're available. That's what we're here for. I do want to emphasize this point about the not here mentality and the power of being a bystander and how we can look out for each other in accordance with a lot of this that we're talking about today. Reporting-wise, there are a lot of options available. So one that's immediately available is your supervisor, whether that's your assistant principal or the director of your department. That's someone you can talk to, but that's not always a comfortable conversation. And because of that, the Human Resources Department, Sarah and Alex and I and Kathy, we are a part of this process as well, and we do our best to always be available and approachable to hear a complaint or to counsel on what our next step is. An analogy that makes sense to me from being in a school building is calling CPS. And I've had conversations with teachers around that. And what I've always said is if you have to stop for a second and think, is this a call I should make? It's probably a call you should make. If it is obviously not a call, it's obviously not a call. But if it's a maybe, it doesn't hurt to follow through and let the person who takes that report, decide what to do with it, or help you do the next steps. So the same thing applies to this. Kristen mentioned that creepy factor. If your creepy antenna is going off, say something. Even if it's something that you witnessed, that you saw someone else experience, we're here to support making this environment comfortable and safe. And that could mean speaking up on someone else's behalf, even if you're not quite sure. Come and talk about it, and we can determine what a good next step would be. Again, with your supervisor in your building or department, or human resources, assistant superintendent's office, there's a lot of options as far as people who can support you with this.